You good to go? Okay, so I'm going to call this meeting to order. So welcome to this evening's Committee of Adjustment meeting. Members of the public, applicants, agents, and staff may be participating this evening either in person or virtually via Zoom. For those attending via Zoom, please note that it is our standard practice for members of the public to have their cameras off and microphones muted until it is time for that member to speak. Township staff can assist with muting microphones. If you require assistance, please use the chat function and ask staff. I am also pleased to advise that this is being broadcast live on the Township's YouTube channel, where a recording of this meeting will be available. Note that the Township does not have the ability to edit the live stream or recorded versions of the meeting. Public meetings have been called and notice circulated in accordance with the Planning Act with respect to applications for minor variances and/or consent. The purpose of public meetings are to inform and provide the public with the opportunity to ask questions and to express views with respect to the applications. The format of the public meeting is as follows. Township staff will introduce the application and report on all correspondence received. Next, the applicant or their agent will present any relevant information. Township staff will then provide further information and clarify any statements of the applicant or their agent. Following that, the public will be permitted to ask questions and express views on the proposal, and then the public portion of the meeting will be closed. And finally, members of the committee will be given an opportunity to ask questions for clarification of the application. After all comments have been received, the committee will consider the application with due regard to the presentations and views expressed this evening. The committee will then do one of three things. 1, approve the application. 2, deny the application, or 3, defer the application pending receipt of additional information. Specified persons who have either provided oral submissions or written objections but disagree with the committee's decision on an application may appeal the decision to the Ontario Land Tribunal as entitled under the Planning Act. The deadline for an appeal of consent application is 20 days within the giving of the notice, and for minor variances within 20 days of the decision date. When commenting on an application, please give your full name and address for the minutes. Please note that the names and addresses for those individuals who speak at this meeting will appear within the meeting minutes, which are public documents. If you wish to receive a copy of a decision, please leave your name and address with township staff. So I'm going to go on to agenda item number 2. Is there any disclosure of pecuniary interest? Seeing none, I'm going to move on to the next item. I'm going to call for a motion for adoption of the minutes. So I have a motion in front of me, motion COA 2025-17, moved by member Bossy, second by member Kish, that the minutes of the March 18th, 2025 Committee of Adjustment meeting be adopted. I'm going to call for a vote. All those in favor, we are carried. Going to move on. So I'm going to call on township staff to talk about D1, which is an application for a minor variance identified as A-11-24.
Thank you, Chair. As indicated, the application is an adjourned application for minor variance located at 3882 West Canal Road. Per the minor variance request, the applicant is seeking a minor variance to recognize the construction of an expansion to a deck that was initially constructed without the benefit of a building permit. The construction drawings submitted by the applicant depict the deck as being an attached deck. As previously discussed at the public hearing heard in July of 2024, the available Environment Canada and Ministry of Natural Resources flood risk map for the Severn River, reflected in Schedule FP2 to the Township Zoning Bylaw, identifies the lands within the mapped floodway area of that map. As stated, a public meeting for the application was held in July of 2024, where the application was deferred by the committee pending further information. Just as a reminder to the committee, the requested variances are for increased lot coverage as well as an increased size for an accessory structure within the floodway area. There was no new comments or objections received from the building, public works, or fire department or the township clerk. Previous comments indicating that the property owner requires an approved building permit is carried forward. With respect to public comments received on the application, as presented at the July 2024 meeting, a list of signatures in support of the application were received from 14 ratepayers, as well as individual letters of support from the property owners of 3874 and 3886 West Canal Road. Since that time, the applicant has also submitted correspondence from Spinal Cord Injury Ontario, previously circulated to the committee as well. As shown on the screen, the subject property is located in the north end of the township on the southern shoreline of the Southern River, directly across from the town of Gravenhurst on West Canal Road, which is a private road. As shown in the aerial imagery on the screen, the subject property is currently developed with a single detached dwelling and various accessory structures ancillary to the principal use of the property. This is the site plan that was submitted by the applicants with their application. As shown in red on the sort of right side of the drawing is the subject deck addition, including the respective variances requested as part of the minor variance application shown in yellow. These are just some staff photos of the deck that were taken in summer of 2024, just to provide a bit of a reminder to committee. So as shown on the screenshot on the screen shared now, this is the flood hazard overlay of the Severn River for the West Canal Road area of the township per Schedule FP2 of the Township Zoning Bylaw. As described throughout the staff report, the current flood hazard mapping available to the township is representative of the federal and provincial flood damage reduction program, which resulted in the 1991 Environment Canada and Ministry of Natural Resources flood risk mapping. As the lower tier municipality, the Township of Severn is required to ensure direction from upper tier governments is upheld at a local level. Therefore, this federal and provincial mapping forms the basis of the flood hazard schedules of the Township Zoning Bylaw. In accordance with provincial policy, the Township of Severn uses a two-zone concept for the map floodplain of the Severn River by identifying areas which are in the floodway or flood fringe. Depicted on this image here, the darker blue is representative of the floodway per the federal provincial study. The blue is representative of the flood fringe, and then the lighter blue is representative of the overall floodplain. Per the findings of the joint federal and provincial study, the subject property was identified by upper tier governments to be within the mapped floodway of the Severn River. It is understood that the map floodway represents an area where possible flood depths and velocities are considered such that they pose an unacceptable threat to life safety and property damage should an unexpected significant flooding event occur. In the context of provincial policy, the lands are therefore considered hazard lands in the context of the provincial planning statement. In the interest of human health and safety, the lands are also captured in that document and considered as hazardous lands. The provincial planning statement prohibits development and site alteration within these areas to avoid preventable risks to human life of all persons. This policy is further reflected in the County of Simcoe and Township official plans, with a few exceptions where it can be demonstrated that the risk to public safety is minor, so as to be mitigated in accordance with provincial standards. The achievement of adequate emergency access in times of flooding, that new hazards are not created or existing ones aggravated, and no environmental impacts will result. At this time, additional information from a qualified professional addressing those items has not been received. Without supplemental information to consider, township staff can only review the application against the current mapping and associated prescribed policy documents as set out by the province. As outlined in the staff report, township staff cannot confirm for certain if the proposed minor variance would represent safe development of hazard lands should a significant flooding event occur. As stated in the staff report, although development in the floodway is generally restricted, the zoning bylaw does include provisions for the alteration or replacement of existing structures, provided the size or height of the structure is not changed. This would also include the reconfiguration of an existing situation, just allowing flexibility for certain types of development within the floodway with subject to appropriate restrictions. The prescribed policies applicable to hazard lands are intended to protect human health and safety and avoid preventable risks to any and all persons. As the lower tier municipality, all decisions of the township and recommendations of township staff are required to be consistent with these prescribed policy documents, hence the recommendation included in the staff reports. As stated, based on the prescribed policy documents and information available to staff at this time, Planning staff recommend that the application be denied as it does not appear consistent with the PPS nor meet the 4 tests for a minor variance as prescribed by the Planning Act. As stated, this application is an adjourned application. It's not subject to a public hearing. However, the applicant is in attendance this evening. Thank you.
Thank you. So I know this is not subject to a public meeting, but there was some information that was received. So I'm going to give the opportunity to the applicant, if they so choose, to come up and speak. And we can go from there if that's if you would like to do that. You can sit right here and turn on the microphone, and you're live on YouTube. Should be on screen, so I believe it's on. I think it's on. I think you're good. Looks like it's green. There we go.
Thank you, committee, for allowing me to speak today. My son, Nicholas, and Tammy Paterson at 3882 West Canal Road, Washago, Ontario. I put together a PowerPoint for you just to give a little more context to what's going on with Nicholas and I. Is there a button I push? Oh, you do that? I think we've already spoken about what relief I'm requesting. What we want to present today is that, in our opinion, the minor variance will align with all of the tests and the policies, and that this application is minor in scope and sharing the facts of the Charter of Rights, also a checklist from the Charter of Rights and the way to ask for accommodations from our township. Suggest support for these accommodations by incorporating them into the bylaw for future minor variances. And also, Nicholas would like to show you evidence the need for the ramp and the expansion of the deck with views from the water and neighboring properties. I live on a floodplain, floodway, and/or flood fringe. It's all things flood. An engineer's report will confirm this. This report would not change this fact, nor would the outcome of the planning department's support of our application. An email I got was, as noted by Tatham, there are no guarantees that the results of their assessment would be favorable. This means the result of their assessment may or may not support your application. There is no guarantee of approval for any Planning Act applications. Therefore, it's at your own risk and it's up to you how you would like to proceed. What we do want to say is we are not less safe because of this deck or this ramp on this floodway, and special accommodations for disability should always be considered. And I think you've seen my site plan, so that's great. I did want to just blow the deck up to give you some idea of what is happening on this deck as Nicholas comes up the ramp, and you will see that in the last video today, and how we laid out the furniture with circulation zones and barbecue and table. So I didn't want people to think it was huge. I'm not near my lot line. I never went to my side setback. I just built what I needed for circulation. The township, the planning committee, the planners think that I am not consistent with the PPS or the other growth plans. But this proposed minor variance application is consistent with the direction approved by the PPS and conforms with the direction provided in a place to grow, the growth plan for the greater Golden Horseshoe. And we believe the following expectations will support both policies. The minor variance will enable an addition to an existing residential dwelling that is considered a permitted use under the PPS. The addition has been designed to maintain the existing shoreline setbacks. The addition can be accommodated with the existing water and sewage servicing on the property. The province is clear in protecting our natural heritage and key hydrologic features and seeks to protect them long-term. The proposed deck is in the exact line of the non-compliant existing deck at 18.3 meters. This addition will not result in any disruption of shoreline vegetation. A shoreline restoration plan has been submitted in support of the minor variance application. The plantings proposed by the shoreline restoration plan will further protect and enhance the natural character of the shoreline to the maximum extent possible. The County of Simcoe official plan. The subject property is designated rural by the Land Use Schedule 5.1 of the County of Simcoe official plan. The minor variance will enable an addition to the existing residential dwelling and shall therefore be evaluated following the policies of Section 3.7 of the County of Simcoe's official plan, which defines the objectives and policies of the rural designation. Resource-based recreational activities, inclusive of recreational dwellings, are permitted within the rural designation. The proposed dwelling addition of decking and ramp is consistent with the objectives of the county's rural designation. It maintains the existing character of the surrounding rural and shoreline area and does not propose a use change that is outside those permitted within the rural designations. The minor variance application conforms with the general intent and purpose of the PPS, A Place to Grow, and the County of Simcoe official plan. The 4 tests. Again, the planning department does not believe we are supporting the 4 tests. So I went through all the 4 tests and I see number 1 is the impact of the variance minor. The test of whether the variance is minor is based on the overall impact of the development on neighboring properties and communities as a whole. Included with the request are support letters from both direct neighbors as well as the signatures of support from West Canal residents. The property is located within a compactly developed residential area on West Canal Road. These lots have widths of 40 to 100 feet and look to have similar or lot coverage values, which is consistent with the proposed lot coverage variances. The owner purchased the property, me, in 2012 with an existing lot coverage of 17%. The buildings on the properties include existing dwellings, deck, detached garage, gazebo, and 2 storage sheds. The dwelling has an existing deck with stairs with non-complying setback to the shoreline of 18.3 meters, the deck and stairs 17.4 meters. The home is within the setback bylaws at 20.7 meters. The existing dwelling and proposed addition decking will result in a total lot coverage of 20%. The proposed deck and ramp do not reduce any waterfront side or roadside setbacks. The requested variance will recognize the legal non-conforming setback to the shoreline of 18.3 to the deck, 20.7 to the house, and 17.4 to the stairs. There is no disturbance of any vegetation. Therefore, there are no negative impacts on the shoreline or shoreline views. There will be additional vegetation added to the front of the deck and additional increase in gardens on the property. Number 2, is the variance desirable for the appropriate development? The proposed deck and ramp addition is requested for the safety of a quadriplegic son who is in a wheelchair full-time with his service dog. This will make the property barrier-free, allowing Nicholas to exit and enter the home safely and allowing him to be independent on his own. The additional width will give him circulation and also a barrier-free pathway. The proposed deck meets the minimum yard sidebacks and rear setbacks of the zoning bylaw to maintain privacy from the adjacent properties and an appropriate distance from the shoreline. I have included a shoreline restoration plan that will make the deck nearly unnoticeable. This will enhance the natural character of the shoreline. We believe that the proposed variance will enhance the property, but most importantly, it will keep and protect the occupants that use it safe. This is the shoreline plan, vegetation plan. Is the general intent and purpose of the zoning bylaw maintained? The subject property is I'm going to have to go here. I'm struggling. The subject property is zoned Shoreline Residential 3, SR3 zone. The SR3 zone permits dwellings and accessory structures. The intent of lot coverage provisions within a zoning bylaw is to ensure that the buildings on the property retain the existing or intended character of an area or community. The lot coverage provision of an SR3 zone pursues minimizing the impact of any buildings on the shoreline and protecting the naturalized area. The proposed deck and ramp do not in any way impact the shoreline, as they do not infringe on any of the setbacks of the shoreline. The extension of the deck is in line with the existing deck, and the majority of deck is on the east side of the home. Section 3.3 of the zoning bylaw provides that development to a watercourse shall have a shoreline buffer across a minimum of 50% of the lot and shall maintain a minimum width of 15 meters. To illustrate the riverfront of 3882 West Canal Road, you will see that the area is completely grassed with large maple tree. There will also be added additional shrubs as pictured to enhance the views from the shoreline. The existing dwelling has a setback of 20.7 to the river, where 20 meters is required. The existing non-complying deck has an 18.3 meter setback, and the stairs have a non-complying 17.4 meter setback. Just a picture to give you an idea of what we're dealing with. Subsection to the provision provided the 4 criteria that applying when considering additions, extensions, or enlargements to these structures on the lands within the shoreline residential zoning categories. The chart hopes to break down the criteria from a homeowner's interpretation. That an enlargement, repair, or renovation complies with provisions 1, 3, and 4 of section 3.19.3. The situation of non-compliance is not further increased. The proposed deck addition is located in line with the non-complying setback deck and stairs. The majority of the additional deck is on the east side of the home with all side setbacks. We are not requesting any further non-compliance increase. Does it pose a threat to public health and safety? The proposed additional deck and ramp were designed for the safety and health of the occupants and will have a positive impact on neighboring property owners. It will increase access and safety for emergency services. All other applicable provisions of this bylaw are complied with. The minor variance approval of the lot coverage increase of gross floor area provisions will establish compliance with provisions of the zoning bylaw. That the enlargement, repair, or renovation complies with Table 3.1. Table 3.1 states that a dwelling with an existing setback of 20 meters from the shoreline is permitted to increase in floor area and or gross area by 60% within this required setback. The existing dwelling complies with the setback bylaw 20.7. The non-complying setback of the existing deck and stairs would allow an increase of 5.8 meters increase. Our variance is asking for an increase of 32 and 8 meters for an uncovered deck and ramp. Any enlargement, repair, or renovation is located behind the projection of the wall to the extent of the front yard or water course setback. The extension of the proposed deck was connected to the non-complying existing deck. to allow a continuous design with continuous vegetation for a visual appeal from the river. The goal was to minimize the impact of our shorelines to the maximum extent possible. The proposed deck addition is added to the non-existing, non-compliant deck on the waterfront setback, deck, and stairs. Is the general intent and purpose of the official plan maintained? The subject property is located within the shoreline residential designation of the township. Those designation objectives are to maintain the existing character of this predominantly low-density residential area, to protect the natural features and ecological functions of the shoreline area and the immediate shoreline, to ensure that the existing development is appropriately serviced with water and sanitary services. The neighborhood of West Canal Road consists of single and multi-story family homes with detached garages. The subject property does have identified natural features, including a large maple tree and shrubs that will not be disturbed or affected. This is to enhance the views from the river and for the enjoyment of other neighbors. The proposed addition can be accommodated with existing septic. The proposed minor variance allowing an increase to lot coverage will result in a built form that maintains the existing character of this area and will not negatively impact any natural or ecological features. The addition would also aid in the safety of emergency services. We believe that the variance for lot coverage and increase of area would maintain the intent and purpose of the official plan. From the Canadian Civil Liberties Association, equality is in its full and proper and legal meaning includes the concept of equity, diversity, and inclusion. It recognized that not every person has the same need or abilities, but that all people are equal in value and worth, and that they are all deserving of equal fairness, dignity, and rights in a meaningful way. Human Rights Code, Section 15, guarantees equal rights and prohibits discrimination based on mental or physical disability. Applies to all government actions, laws, and policies. Has been interpreted by courts to require reasonable accommodation for persons with disabilities. Municipalities must consider human rights obligations when creating and enforcing bylaws. The accommodation must be provided unless it would cause undue hardship to the municipality. The definition of undue hardship is limited to excessive cost, outside funding sources, or health and safety concerns. Any municipal bylaw that creates barriers for people with disabilities may be challenged under the Human Rights Code. And an email that I received on October 10th from the Planning Department. Although the township sympathizes with your situation, the township, our bylaws and processes must treat everyone equally, and therefore we cannot provide you with special treatment on the deck you've allowed to be constructed on your property without a building permit. The options for addressing the municipal bylaw issue: request accommodation from the municipality, submit a formal accommodation requesting to the municipality, explaining the nature of the disability, why the deck and ramp are necessary, how it would provide equal access to the home and eliminate all safety issues for the family and emergency services, of which I have done number 1. Number 2, I am doing today. Appeal to local planning authorities, appeal to the local committee of adjustments or planning authorities. Some municipalities have processes for minor variances or exemption to bylaws. Frame the request as a human rights accommodation issue. The next would be file a human rights complaint, and also consult municipal accessibility advisory committees. The overarching principle is that when accessibility standards or municipal bylaws conflict with Ontario human rights codes, The provision that offers the highest level of accessibility prevails. This means that even if the municipal bylaws restrict expansion, the human rights obligation to accommodate disability will supersede it. I was interested on how much more percentage a disabled person would be using and why they do deserve considerations. So my 4 steps to get to my deck is 1.5 square meters. The ramp that we are asking for Nicholas is 8 square meters. So there should be consideration. Disability changes with age. If the township's economic goal is to continue welcoming residents, it should adopt a proactive approach related to disability accommodation. And in conclusion, this request for a minor variance protects my child and allows him the enjoyment of his home independently. A request that any parent or family member would expect from their municipality. Allowing considerations in the bylaw for disabled persons must be implemented. The deck, again, does not make us more unsafe in a flood. And Nicholas would like to come up and show you some circulation, showing the waterfront views of the deck. Oops. Dum, da, da, dum. How Nicholas is using the ramp, his circulation zones, and the impact on our neighbors.
Yeah, I've done so much fun. Yeah, but yeah, so basically, I took Jonah and flew it out to from the river. You can see that it doesn't like look like a match thing. It's not an eyesore, you know. You don't like those from the river too much. And then like one basement, one side of the neighborhood.
Sure. Why? Why though? Why?
Because we didn't have one that.
For him to correct.
Like, so it's, you only have like so many feet, come down the ramp, and then that much room, and, you know, there's no room to correct. You know, we need that kind of feet to just the ability to correct, so it'll go off the deck. So it's done off the deck, I don't want to be off the deck. You know, but yeah, that's.
Thank you for listening to us. Do I stay or should I?
You can stay right there because I'm sure there's going to be some questions. Do township staff have anything further to add to materials and information presented to the applicant or their agent, or any recommended conditions?
Thank you, Chair. I don't have anything further to add at this point in time. However, staff have a recommended motion. Should committee wish to see it.
Thank you. As planning staff had mentioned before, this is not a public meeting, but we did give the opportunity to the applicant to speak. So will be no other public input. So I'm going to turn this over to the committee. Do any members of the committee require further clarification or wish to provide comments or have questions for the applicant on this application? Member Bossy.
Through the chair, to the staff, there was a new build, I think third from the end of the road. Would that have been over an existing structure or a replacement of an existing structure?
Planning staff.
Thank you, Chair. So the development rights, as indicated in the staff report, do depend on whether that property was in the floodway or the flood fringe. Committee, well, some of the members who've been on the committee for a long time may recall previous minor variance applications within the floodway along this portion of West Canal Road, where engineering demonstrating that those specific requirements, safety, safe access, all of those types of items had been addressed through the information provided by their qualified engineer. In a previous situation, that was the consolidation of footprints. So keeping the same amount of coverage, just kind of changing the configuration on the property.
Member Bossy.
Question to the applicant. When you look from the river to your house, there's a house to the left, the brown one, I think. Did that have an addition put on? I can't remember.
The really pretty one with the, like, further down or down?
Right to your left, when you're looking from the river.
Oh. My neighbor, like my direct neighbor?
Yeah, or am I dreaming?
Ask me that question again?
Okay, so you're looking from the river,
Yes,
the house to the left, what color?
yes, my neighbor, Charlie, yes. Brown,
Brown. Did he do an addition?
no,
Okay, all right, I thought he did. All right, never
not
mind.
that I'm aware of.
Okay.
Head Member Hawkins.
Through the chair, the planning staff, as you mentioned, they can reconfigure existing footprint of what they have. So the existing portion of the deck across the front of the house, could they reallocate that square footage to this addition?
Through to the planning staff.
Through the chair to Member Hawkins, we'd likely want to see some sort of design to be able to confirm that. However, the wording in the bylaw is specific in that relocation is permitted, provided that the size, height, volume doesn't change.
I know in your presentation, you mentioned that you did do a request for an accommodation of the municipality. Are you able to share what the results were of that request?
Well, I'm considering the planning department being that.
So you're under that presentation, it was the planning department would have been step 1 and step 2, or numeral
would be.
1 and that. Okay. It's a tough one. Member Bossy, go ahead.
Question to staff through the chair. The township has an accessibility committee or something, don't they? Have they looked at it, or do they have any input in on this?
Township staff.
Thank you through the chair to Member Bossy. The Township of Severn does have a joint accessibility advisory committee with the Township of Ramera. The applicant could inquire with the clerk as to that process. However, I would just remind committee that all decisions of the municipality need to be consistent with the prescribed policy as presented in the staff report.
So this is a tough one. If you got another comment, I'll let you say one more comment.
I actually spoke with my with mayor and also with my counselor, and I have requested that I could possibly put my hat in for the accessibility committee, because I really believe that someone, a family, shouldn't have to go through this, and there should be provisions, but there should also be very specific expectations of those. So Nicholas, whether that's medical, whether that's medical doctors telling you that what kind of things, or therapists, or that type of thing, it shouldn't be just a free for all. This should never be like, give her consideration. It should be very specific, looking at the whole picture instead of just the one bylaw that's not allowing a little bit of room for us to have that accommodation. So I believe that there should be accessibility. You should be speaking to someone in the committee so that you have you know, a little bit more support and more ideas of how to give people what they request based on real need.
I guess I got a question through the planning department. When's the next revision to your planning documentation coming up?
Thank you, Chair. So we did complete a recent housekeeping amendment in April of this year. However, now that the new official plan is in place, as committee is aware, we will be subsequently doing either a new zoning bylaw or further amendments to the existing zoning bylaw at some point in the future. When that comes forward, there would be opportunity for public input. It would be subject to a public meeting for council, all of those types of things, as with any other zoning bylaw amendment process.
So we're talking 1-2+ years out.
Unfortunately, at this time, I wouldn't be able to confirm. It is something that is a priority for staff, but I don't have a crystal ball as to when that would be brought forward, but notice would be provided on township social medias, on local online newspapers such as Aurelia Matters and those types of things.
Another question to staff. If we, I'm just thinking outside the realm of what's going on in my head. If we defer the application this evening, pending additional information or pending whatever, whatever the wording may be, you know, would the applicant still be able to continue on with their current situation of decking that's in place until such time the application is brought back to the committee, and say it's 24 months or something like that?
Thank you through the chair. The committee can choose how they would like to decide. Just advising committee that, as a reminder, it is a building without a permit issue, so there could be timelines under the Ontario Building Code through the chief building official. And just to kind of go back to the future housekeeping, any policies of the zoning bylaw are required to be consistent with provincial and county direction. So just keeping that in mind, that all decisions of municipality are required to be consistent with those prescribed policy documents.
Thank you. It's a tough one. So I can see it. Honestly, I can see it how you've discussed it this evening. You know, I also see you know, the bylaws are in place, the planning act, all that's in place, the building code's in place, and we have gone ahead and we've built a structure that wasn't that would have required a building permit. We should have followed that process. I look at it from a committee perspective, and I'm just one vote up here and I'm chairing the meeting. As I discussed in the preamble of the meeting, you know, really we can do one of three things. One, it's deny the application, as what the township township staff have recommended, which is in the report. because they've looked at the Planning Act, they've looked at the 4 tests, they've looked at what's been presented. That could be one way. The other way is to approve the application, how you've submitted the application and presented this evening. Or the other option is to defer the application, which we've already done. And we requested at that point, I know there was a list of things in the deferral. It's going back a year now. But I think it was supposed to be looked at from a qualified person or whatever to deal with the flooding and flood, whatever we want to call it, flood zone and all that, and bring back some additional information that there would be no impact. I would be more, and I'm just speaking on behalf of the committee because I don't have a question or comment. I have a hard time deferring this application because at the end of the day, I don't know if we defer it, the applicant then has to deal with the deck, has to have more stuff that happens. If we approve it, then the township has the ability to go and the township has the ability to go and just appeal the decision. Yes, correct. Appeal the decision. And where does that leave us in a legal battle going back and forth? If we defer the application, I'm going to be honest with you, I would prefer that. And I would bet that you should be working with township staff and working with a qualified professional to figure out how to move forward. And I think, honestly, when I look at it from a whole perspective and above, I think that is the best route. And that's the route that we tried to do the last time. I know there's costs and all that involved, but there's costs in every step. There's going to be costs in every step. I think the deferral is honestly the best. I have also sat in this position up here 12, 14 years, somewhere in that range. And we have done deferrals for similar things in the past. The deferral allows the applicant to work with the township staff. They've already paid their fee. From my perspective, I know it's not probably what you want to hear. That's the way I would prefer to go this evening. I don't think either the denial or the approval at this current point is the way that I feel most comfortable with. I will allow you one more time. Go ahead.
I've already spoken to Tatham. I've already gotten quotations. I've already wanted specifically to know what the township wanted. I've detailed it in that timeline that was attached. The point is that I am on a floodway. I am in a flood zone. There's no question about that. And I'm not going to have a positive result. So we're going to be doing this in another 2 years, in another year or 6 months. If I was told, based on where I live and what has happened even on West Canal, that, you know what, there's a good possibility that you'll get something that the township can support, like the planning department can support. I would have done it all day long. And that has not, I've just been told almost all the time, there is no guarantee. And I know that I'm not going to have a favorable result. So why am I going to spend $5,000 to $10,000 on something I already know it is what it is, right? So I guess when you say deferral, that means I don't have a safety railing on for however long that is for my son or for other people. It's either we look at, the rights of a disabled person, and they are available, and trust me, I've talked to my disability lawyers, a planning lawyer. I know where I sit, and it's just not fair. There should be provisions. I'm not asking for massive provisions, right? I am not. It is not that big. It's an extra 25 square feet. based on 1.5 stairs and 8-foot ramp, that's not a lot asking for a wheelchair user. So deferring it is just going to extend this, and the last 2 years have not been fun doing this. So I would have spent that money all day long if I could have come here and they would say, of course, Tammy, you're on a flood fringe, we'll support you. But they are not saying that. They are saying most likely I won't get it. So deferral is really not an option for us, because we'll need to move on to the next. And we're prepared to do that.
Member Hiles.
Through the chair to the planning department. If we were to proceed with denying the application, what steps can then be taken by the applicant?
Thank you through the chair to Member Hiles. As with any minor variance decision, after a decision is made by the committee, there is the 20-day appeal period. Applicants are certainly welcome to exercise their rights to an appeal should they feel like that's necessary.
Member Hawkins.
Just through the chair to planning with my earlier question about the footprint of the deck. If the applicant came back with a proposed footprint that meets the existing footprint, just in a different iteration, would the engineer's report still be required?
Planning staff. Oh, Katie Mandeville. Look at that. You can unmute your mic. So Katie is from our planning department. So go ahead.
Thank you, Chair. I just wanted to clarify something that the applicant just said. They mentioned they're asking for a 25 square foot increase, and you will note that in the staff report, planning staff talk about the increase being a 32 square meter increase, as well as the 8 square meter ramp. So if we're talking about reallocating the existing decking space or, making changes to that, I just want to keep those numbers in mind, since it was mentioned that it was 25 square feet that they were asking for earlier. So I just wanted to bring that back to the committee's attention. The Township Zoning Bylaw, as well as the Planning Act, they allow for a reconstruction of what was legally there. So had this applicant come in for a building permit and reconstructed the front portion of the deck that was already there, that would have been permitted as of right without any minor variance requirement. They may have been able to add a ramp or small addition to that deck under the provisions of the bylaw, given the floodway. However, what we're talking about here is a deck that was previously 69 square meters and then received an additional 32 square meters plus an 8-meter ramp. So although we have been trying to sympathize with the applicant's situation, we fully agree that accessibility accommodations are available for accessing information, accessing township facilities and resources. Unfortunately, the Planning Act doesn't give a minor variance test or policy direction to allow larger decks or larger structures in floodways because someone has a disability. In fact, we are not allowed to people zone. We are not allowed to actually look at who lives in that property and who uses that property when we judge an application. We have to judge it on the merits put forward by the Planning Act. And one of those things is human health and safety. This is a mapped floodway. We restrict structures in floodways for health and safety, for access, for risk of flooding. And that's why you see the recommendation before you. So I just wanted to kind of clear that up a little bit. My apologies, I couldn't be there in person today, but I just wanted to kind of refocus that discussion a little bit and offer a little bit more perspective. I believe Member Hawkins had a question there directly about the need for an engineer's report. That was coming from what we've seen in the past on many properties, and the committee has dealt with also on properties, is that sometimes the mapping is not accurate. So sometimes someone can hire an engineer and they can ground truth that, 1991 mapping and find out that they're not in a floodway. And therefore, different policies then apply to their property. So I think that's important to think about as well. The committee members might also be familiar that when someone builds without a permit, sometimes they need a structural engineer to confirm what is built. Another representation made by the applicant is that it's a detached deck, whereas the building permit drawings show it as having to be attached to the house under the plans submitted with the building permit proposal, which was submitted after the deck was constructed. So there's just a little bit of contradicting information being shared, so I just wanted to try and clear some of that up.
Thank you. Member Kish.
So through the chair to staff, from the engineering standpoint, is it that we would be verifying that the mapping is accurate? Or if an engineer was to deem that it is a safe structure, even if it did flood, that would be considered acceptable? Or is it literally just for the mapping aspect?
Thanks.
Thank you through the chair to member Kish. I can provide some information. However, Ms. Mandeville has worked on other applications similar to this in the past, so she might also want to step in. It would be a bit of both. One, we'd want to refine the mapping. And two, the provincial policy, county policy, and township policy all talk about making sure and demonstrating that it's safe, that there would be no risk to human health and safety, and that it can be safely accessed, all of those types of items. So it would be one, refining the mapping, but two, confirming that it's safe. I'm not sure if Ms. Mandeville might have something additional to add to that.
Ms. Mandeville.
Thank you through the chair. So that is correct. It's a combination of those two things. The committee in the past has seen applications on floodway properties where a flood study was done. We've also seen larger development files that had a flood study done. So basically an engineer would look at the risks associated with the new structure and what that meant in terms of flooding, both for the structure, but also for the property, any risks that the debris from the deck, like what may become debris from a structure. So in this case, from the deck, would that then go downstream? Would that cause damage to a downstream property? All those things have been looked at on larger development files where we've done development within a floodplain or a floodway. So those kind of things could be looked at in support of an application as well. And that's why that's kind of one of the cores of why we say it's such a small area or a small structure that can be built within the floodway, is because from my understanding, although I'm not an engineer, that is not my area of expertise, it's the debris that comes from those structures, those small scale structures that can then wash onto a neighboring property or down the river in events of flooding. So sometimes things like that are also looked at during an engineering study. And that's why we have been working with this applicant for, over a year now to try and get them in touch with a qualified professional and try and see first if the mapping is accurate. And then second of all, what the risks to the property, theirs and others, would be in a flooding event.
Member Bossy.
Through the chair to the staff, the Severn River through that section this year was pretty high. Do we know, like on 100-year basis, what that was like? Because it's the highest since I've been there this year.
Thank you through the chair to member Botsy. Planning staff wouldn't be able to comment on that. That is something that would be considered by an Ontario land surveyor or a qualified engineer to confirm those types of things. But that is largely what these policies are in place for, is to plan for these unexpected events, such as an unexpected 100-year flood or a dam failure upstream or those types of things. The policies are put in place to protect both human life and property from possible damages should a significant event occur.
Any further questions from the committee? So I guess I got one option. Can bring it up. We can deny the application. I can bring it up. We can put through another recommendation to approve the application. I can bring it up and put through another motion to defer the application. And I'm willing to do whatever, but I need kind of guidance on what type of motion we would like to see if we're differing from what is being recommended. Okay. Speak in the microphone.
I'm in support of a deferral. if they so choose to use that time.
I would add the same thing. It would be in support deferral. And maybe there's an option of them to reconfigure the deck footprint to use the original 69 square meters in a new way with the proper building permits to achieve that.
Can also get on board with that. My only concern with that is the applicant has kind of voiced their opinion that they would prefer not to have a deferral. So that would be my only reluctance towards a deferral, is if the applicant would rather receive the either denial or approval, which obviously they would prefer the approval, but if they would prefer the other options just so that they have the availability to use other avenues, that would be my only concern, so that we're just not delaying this longer and longer. So I don't know if we want to go back to the applicant and ask them again now that there's been further discussion. That would be my only thought with the deferral option.
Okay, thank you. So to the applicant, so I got a number of committee members, including myself, that would prefer the deferral route, which would give you the opportunity to work with the township staff and a qualified person to determine the next steps that way. I can bring that motion up and we can go down that route and give you, say, 12 months or a year or whatever to go down that route. And I know that doesn't put you in the best of situations because you do have your own concerns with railing and stuff like that you prevented from doing. Or we can vote, and the first vote would be to follow what the township had recommended and deny the application. And we can vote it out. And if we don't have enough votes for a denial, then we would go to the next step, which would be an approval. And then if we don't at that, then we could go to the next step, which I think in the process in my mind would be deferral of the application. Correct, township staff?
Thank you, Chair. If the motion's lost, the committee would be able to consider an alternative motion.
Yeah. And by saying that it would be lost is if you didn't have support of a majority vote. So I'm going to give you the option on if you would support a deferral or if you want us to go through and vote.
I suppose the question would be for, because I mean, I 100% would have tried to work with the planning department. I guess that questionable result is my big thing because I know where I live. So I'm wondering where that question is, and if I have to pay, if that's the cost of it, and I come back to you and they say, well, we can't support it because she is on a flood fringe and she doesn't have enough height and she doesn't have all of these things, and here we are in a year, right? That I guess that's my concern, and I don't know how much support I will get from planning. I guess that's my concern, and that's.
So I think what I'm hearing tonight, and if someone wants to correct me, please feel free. You know, you might get down the path where, you know, you have qualified professional come and identify that you are on a flood fringe or floodway or flood path or whatever we want to call it. But your structure is built in such a way that it's not going to cause a safety hazard to whatever downstream people and all that, and maybe then it's looked at in a different way. But that's kind of where we're at.
Right. And I would not be concerned about that whatsoever. It's what is I guess the concern is someone's interpretation of what that is. I don't even have something to compare it to. Even the homes that have been done on my street haven't had to have this, so I can't compare it to something else. But if they tell me they need it and they would be able to support me,
and I will speak
100%.
And I will speak to that. So if you don't have anything to compare it to, that doesn't mean that a planner doesn't have something to compare it to, right? So there are many professionals. There's professionals in this room. There's professionals that work for other companies that have done that have done business with other applicants that are out there, whether it's in this township, whether it's in Orabadante, whether it's in Aurelia, whether it's in Romero, whether it's in Muskoka, that have probably dealt with this same situation before and have gone through, right? So I know you might have not dealt with it, but I'm sure if you phone some sort of planning company, I'm sure they've dealt with a lot of this type of things in their career. I'm sure there's a lot of knowledgeable planners out there that have dealt with this as part of their private practice. So that's, I think you can make the decision. I think the best bet is to give you the time to figure it out, because I honestly think I don't want to waste anybody's money. And it's not my money, but I would prefer you go down the route, exhaust, ask the questions to the people that you need to ask the questions to. I'm sure there's a lot of business owners out there that would take your phone call and work with the township. That would be my recommendation. Member Bossy?
Through the chair, question to staff. When we talk safety, we're not, is it from the debris itself, or is it the safety of the occupants of the house?
Township staff?
Thank you through the chair to member Bossy. Again, it's a mix of both. It's the structural integrity should an event occur, does that exacerbate risk to human health and safety or possible property damage either on the property or downstream?
Member Bossy?
To staff through the chair. So on this one, we're not adding more people, we're not adding bedrooms, we're not adding like we're not adding a people issue. So it sounds to me like it's a debris issue. And if Lock 42 goes, I think there's going to be a lot more debris than one deck. That's
Emily?
Thank you through the chair. Unfortunately, I'm not a qualified professional engineer, so I wouldn't be able to comment on what the risks might be, whether that's two individuals residing on the property, accommodating further development in the floodway, obstructing the path of flood flows, things like that, or if the greater risk is further downstream. Again, that's the discretion of a qualified professional engineer who could evaluate all of the different characteristics of the situation and different factors that contribute to the situation, informing their opinion.
Member Kish?
Through the chair to township staff. So if the property was still deemed to be on a flood way, plain, whatever flood thing it is, and an engineer basically said that they deemed the structure to be safe and able to withstand the 100-year storm or whatever it be, at that point, would township staff be more supportive of this, or being that it's still in the flood way, plain, whatever, would still have to propose the denial?
Through the chair to member Kish, I wouldn't really necessarily be able to comment on that until we saw an opinion. It largely depends on the justification provided with that opinion. As with any minor variance application, as committee is aware, there's prescribed policy in the Planning Act that the applicant has to demonstrate consistency with. So ultimately it would depend on the justification along with those other factors you've identified.
So I think I think we've asked enough, exhausted the questions this evening, and I think there's an opportunity to defer the application. I think that's the best bet. If you're in support of that, I think that gives you a little bit more time to figure things out. Okay, so I'm going to call for a motion to be created on the fly. And I know it's pending additional information from, oh, look at that. No, sorry, I just, yeah, it's no, there's no more public stuff. So we're gonna stop that there, and I'm just gonna read through this. I'm good with this. Everybody else good with this? Okay. So I have a motion before me identified as COA 2025-18, moved by member Hawkins, second by member Hiles, that staff report D25-012 be received and that minor variance application A-11-24 be deferred to a future committee of adjustment meeting pending receipt of additional information to address the concerns and policy discussed in staff report D25-012, and that the application be brought back to the committee for consideration within 1 year. I'm going to call for a vote. All those in favor, we are carried. I would encourage you to leave this evening, enjoy your evening. I would get on the horn with township staff. There's a lot of great people that work here, whether it be the people sitting here or with us tonight, or Miss Mandeville, who's been here for pretty much the same amount of time I've been on this committee. They can provide you some names of some people that have worked here with this township in the past or other municipalities, and help you out, and then we'll get you back here. So I would just encourage you to reach out and continue reaching out and opening up, having an open communication, and seeing if you can move forward with your application.
Thank you.
Okay. So moving on, the hearing for that application is now closed. We're going to move on to the next application. So would township staff introduce the application and report on any written response to the notice circulated for a new application identified as E1, which is an application for consent and minor variance identified as B-06-24 and A-10-25.
Thank you, Chair. As you've identified, the next application are concurrent applications for consent and minor variance affecting the lands recognized as 8201 Highway 12. The subject property is currently zoned highway commercial along a haul route, subject to exception 6. I would just note that the exception applied to the property limits the uses of the lands to a car dealership. That's the exception 6 applied to the lands. The applicant is seeking consent for the creation of one new commercial lot with an easement in favor of the retained lands for the purposes of stormwater management. A concurrent minor variance seeks reduced lot frontage on the retained lands to facilitate the proposed consent. The applicants have completed a traffic impact study in support of their application. This application has actually been ongoing since the spring of 2024. And previous to that, the applicants did complete a pre-consultation with the township and the Ministry of Transportation. The proposal you're seeing before you this evening is actually a revised proposal taking into consideration comments made by the MTO, as well as the results of the traffic impact study. As described in the staff report, it's the understanding of staff that the revised proposal and traffic impact study considers and incorporates the suggestions made by the MTO. However, they are still currently reviewing that. So just wanted to make note of that. So as shown on screen is a summary of the application. So as described in the staff report, the retained lands would have a lot frontage of 54.8 meters along Fairgrounds Road. That would be what the concurrent minor variance seeks to address. The severed lands would have a frontage of approximately 116 meters along Highway 12. With respect to lot area, the retained lands would have an area of 2.0 hectares, with the severed lands having an area of 1.37 hectares. The only lot statistic that isn't compliant with the zoning bylaw is that frontage along Fairgrounds Road, for which the applicants have acknowledged their minor variance application. This is just a proposed severance sketch. As shown in yellow is the boundaries of what is proposed to be the retained lands. As shown in the striping on screen, that is the area that would be reserved for an easement in favor of the retained lands for the purposes of stormwater management. You can kind of see it on the screen there. There is an ongoing stormwater facility on the property. So this would just seek to protect those rights should this lot be severed and developed at some point in the future. Comments from departments and agencies, including the County of Simcoe, state that the lands are located within the South of Division Road secondary plan and therefore would defer to the township's official plan. Then they further note that all development proposals should be consistent with the provincial planning statement as applicable. The building department states no objections to the proposed consent application for severance. They have not reviewed any proposed designs for future development at this time. Any drainage from the retained property through the severed lot would need to be addressed. Location of storage containers on the retained lands may be too close to the on-site septic system. The septic system on the retained land remains open and is pending a sign-off and as-built drawing from an engineer. This would be addressed through this process. As discussed in the staff report, the Public Works Department has no objections or comments on the creation of the severance. There would just be need to have further discussions when the lot is prepared to be developed with respect to access to the property, where the access is provided. In the future, any applicant would be required to go through a site plan agreement, so it's likely that these types of items would be addressed at that point in time. The applicant's agent from Morgan Planning and Development is in attendance this evening, and I do believe they wish to address the committee.
I don't know if they're in attendance. I believe they're going to join us virtually. So I now call on the applicant's agent to present any relevant information they have. So feel free to unmute yourself, and I know you turned your camera on, and if you have a presentation you want to share your screen, go ahead.
Yes, thank you, committee. Okay, so I share my screen. Give me a second here then. Just rejig things. Share. Screen 2. You should see the presentation. So good evening, committee, staff, and members of the public. My name is Vanessa Simpson. I am here from Morgan Planning to represent the applicant, Sunrise Toyota, on the proposed consent and concurrent minor variance applications for lands addressed 8201 Highway 12.
Ms. Simpson?
Yes.
Can you show your presentation? You might have dual.
Oh, why isn't it doing this? This happened to me last time. And slideshow. Which part can you see? Screen. Okay, here we go. Now you can see it.
Got it.
Okay, just let me press this button. Okay, you can see it? There we go.
Yep.
Okay, perfect. So the subject property is located at the north west corner of Fairgrounds Road and Highway 12, with 207 meters of frontage along Fairgrounds and 235 meters of frontage along Highway 12. The total lot area is approximately 3.3 hectares, and the current car dealership is serviced by private well and septic system. I'm going to skip through this. I'm just speaking to it on the slides. The western portion of the site is developed and occupied by Sunrise Toyota. I'm sure you're all familiar with it. And the eastern portion of the site remains undeveloped. Vehicle access is provided from both Highway 12 and Fairgrounds Road. A stormwater retention pond, you can see here, is situated on the eastern half of the property. I'll also note the septic system is located on this area of the property if you were questioning that. The property is zoned highway commercial on a haul route with an exception, which, as stated, is reducing the permitted uses to motor vehicle dealership. And the property is designated highway commercial within the south of Division Road secondary plan. Brief overview of the consent application. It is to create one new commercial lot. The severed lot complies with the applicable zoning. The retained lot does not meet the required lot frontage, and therefore a minor variance application has been submitted to address this deficiency. In addition, an easement application has been submitted to permit the storm water from the retained lot to drain through to the severed lot. And the lot statistics are shown here, and the highlighted deficient lot frontage for the retained parcel is noted. So the relief requested for the minor variance is requesting a minimum lot frontage of 54 meters, whereas 60 meters is required. The retained parcel, which is, again, just to remind you, the Sunrise Toyota lands, does also have frontage on Highway 12. The variant, no variances are requested or required for the severed lands. And the proposed variance aligns with the general development policies of the highway commercial zone and meets 4 tests of the minor variance, which are fully detailed in the planning justification report. Provided here is the lot configuration for the severed lands, which are shown in yellow. The lands to be retained will continue to contain Sunrise Toyota vehicle dealership, including both existing entrances. As you can see, the severance creates an L-shaped parcel for the Sunrise lands, deeming Fairgrounds Road as the lot frontage, which is deficient. An easement is required over a portion of the severed lands, which is where the existing stormwater pond is located. You can see that in the hatched line work. This will allow for continued service and collection of stormwater, as well as any maintenance or modifications that may be required in the future when a development application comes forward. Provided here is a proposed concept plan for the severed lands. At this time, no development is proposed. However, a car dealership is shown on the plan just to provide some context, and an entrance onto Fairgrounds Road would be provided. This concept plan has been discussed and reviewed by the MTO in previous meetings with the first application that had been submitted for this property. A plan and justification report was submitted with the application, which addresses all applicable policies. A traffic impact study was also prepared and submitted by Tatham Engineering. Key findings include the existing access to the retained parcel remain, new access to the severed parcel proposed from Fairgrounds Road, no anticipated impact on adjacent road network operations, sightlines meet the required minimums, turn lanes are not required, and the MTO has reviewed the concept plan and the traffic impact study. In conclusion, the applications propose to create 1 new commercial lot, therefore creating 1 retained lot with the existing motor vehicle dealership and 1 severed lot for future development. Minor variance applications has been submitted to permit reduced frontage for the retained lot. The traffic impact study has been completed in support of the applications, and the concept plan for the proposed dealership has been prepared in consultation with MTO. The minor variance application satisfies the 4 tests under the Section 45 of the Planning Act. And that is a conclusion of my presentation. We have reviewed staff's report, recommendations, and the conditions that have been proposed, and we don't have any concern with addressing those. Thank you.
Thank you. Do township staff have anything further to add to the materials and information presented by the applicant's agent this evening? And I guess if they don't, then can we go through the recommended conditions if applicable?
Thank you, Chair. I will keep it relatively brief as Ms. Simpson has provided a great overview of the application. Do you mind just go ahead? So as shown on screen is the proposed severance sketch as indicated in the staff report and identified by Ms. Simpson. The lot configuration shown on the screen was developed in consultation with the MTO. Planning staff at this time have not reviewed any concepts or development concepts for the possible development of the severed lands. A future site plan agreement would need to contemplate things such as access, parking, servicing, those types of things, recognizing that future additional process would need to occur at some point in the future. While the MTO is still in the process of reviewing the TIS, staff are comfortable that those items can be addressed at the point of site plan control, as the final proposal hasn't been developed at this time. As a condition of the provisional approval of the application, staff have recommended a consent agreement be registered on title. The purpose of the consent agreement would be to forewarn any future purchasers that there is the TIS that would need to be adhered to, any recommended mitigative measures, that the MTO and the township both need to be satisfied with any future development potential of the property. So that would provide protections to any future purchaser. there's not objection to the creation of the lot, the discussion remains around access to the lot. So given that the final configuration or development proposal for the severed lands hasn't been developed and is subject to change, staff are comfortable that the future site plan agreement could address these matters. With respect to additional conditions, as noted by the building department, there is some concern with the location of existing unauthorized storage containers on the retained lands. In concert with the consent agreement, staff recommend that a site plan amending agreement for the retained lands also be completed to address those matters such as the outstanding septic permit, those types of items. There's some staff photos that were taken during a site inspection completed by staff. As shown on the screen is a panoramic photo of the location of the severed lands, depicting the approximate sort of size relative to the existing car dealership to the left of the screen. As shown here, these are the shipping containers identified by the building department that are intended to be addressed through the conditions of the provisional approval. Morgan Planning and Development, and as outlined by Ms. Simpson this evening, have provided planning justification in support of the application over providing an overview of the PPS township official plans and the test for a variance. The recommended conditions include that consent agreement to notify possible future purchasers of that traffic impact study and MTO and township requirements. And the commercial site plan control requirements would be an additional added sort of protection for any future property owner and to ensure that the township zoning standards are upheld. Therefore, planning staff have no objections to the provisional approval of the consent application and subject to the recommended conditions, as well as the approval of the minor variance as requested. I will go over the recommended conditions of consent. So as indicated on screen, standard for any consent application or reference plan will need to be prepared and provided to the township for review prior to registration. Copy of the in preparation draft deed, that the applicant apply and receive a minor variance approval to recognize the reduced frontage, which they are concurrently doing this evening. That the applicant apply and complete a site plan amending agreement for the retained lands at their sole expense, including the completion of the open building for the on-site septic system to the satisfaction of the CBO. That an easement be registered and titled to the proposed severed parcel in favor of the retained lands for the purposes of drainage and stormwater management. This would also include an acknowledgement that future on-site sewage services for the proposed severed lands may be located within the easement area, but shall not interfere with the drainage of the retained lands. That the property owner enters into that consent agreement with the municipality pursuant to section 5126 of the Planning Act. Would include the warning clause regarding the separate entrance is not guaranteed and would be reviewed against the applicable policies and bylaws and industry standards at the time of site plan application. That would need to be done to the satisfaction of the township as well as the MTO in the form of their building and land use permit or an equivalent. Again, that was something that we would include as a recommended condition to forewarn future purchasers that would be a requirement at the time of development. And again, echoing that sentiment, that a site plan agreement with the municipality would be required prior to any development or site alteration taking place. That municipal taxes shall be paid in full up to the date of request of issuance of the consent certificate, that all fees are the responsibility of the applicant, and that these conditions be completed within 2 years of the date of the decision. Staff do have a recommended motion for committee should they wish to consider it.
Thank you. We go to Zoom first. So are there any persons participating virtually via Zoom who have either questions or wish to speak in favor or in opposition to this application? We have none. Okay, so we're going to move to in person. Are there any persons in attendance who have either questions or wish to speak in favor or in opposition to this application? Seeing none, I declare the public portion of the meeting closed. Do any members of the committee require further clarification or wish to provide comments on this application? Seeing none, I'm going to call for a motion. Motion in front of us identified as COA 2025-19, moved by member Kish, second by member Hiles, that staff report D25-13 be received, and that the matter of consent application B-06-24, the application be provisionally approved, subject to the recommended conditions included as attachment 5 to staff report D25-013, and further that in the matter of minor variance application A-10-25, the application be approved. And a call for a vote. All those in favor? We are carried. The hearing for this application is now closed. Anybody that's interested in this application are free to stay for the remainder of the meeting or leave as the committee moves on to the next application. So would township staff briefly introduce and report on any written response to the notice circulated for E2 on our agenda, which is an application for consent identified as B-03-25.
Thank you, Chair, and good evening, committee. So the next application is consent application B-03-25 for lands located at 4203 Smith Lane. In summary, this application is twofold. So first, it does propose a lot boundary adjustment to correct the encroachment of an existing dwelling, as well as establishing a right-of-way that over an existing driveway to legalize that access. No new lot would be created as a result of this application. The lands outlined in red here are the lands which are proposed to be severed from the subject lands and added to the benefiting lands, correcting the encroachment of this dwelling located here. There is a second dwelling a little bit closer to the shoreline, but just for the committee's clarification, that dwelling is proposed to be demolished, therefore not proposed to be corrected through this application. And the lands highlighted in the light blue green color here, indicated as part 1, are the right-of-way lands. Just recognizing the location of the existing driveway, providing access to these lands here. To summarize the correspondence, the building division advised that there is no objection to the lot boundary adjustment or the right-of-way aspect of this. The division did note that there may be some building without a permit occurring at 4207 Smith Lane, which are some neighboring lands, but still part of this application, given the proposed future consolidation. And the building division just notes that they will follow up with the property owner on this, sort of separate from this, and therefore no conditions are recommended by the township to address that matter. The County of Simcoe did advise that the township and committee must confirm that the consent pertains to legal or technical matter that does not result in the creation of a new lot. And finally, no comments or objections were received from the Public Works Department, Fire and Emergency Services, or the township clerk. So I will leave it at that for the time being. The applicant's agent, Ms. Loft of Loft Planning, is in attendance this evening and does have a presentation for the committee as well.
Good evening.
Well, welcome.
Thank you.
Microphone on. Pretty sure.
Is it on?
Just tap it. There you go. You're good.
We're good. Good evening through the chair to committee. My name is Kristine Loft of Loft Planning, and I am representing the landowners of 4203 Smith Lane. And next slide, please. So the subject lands are described as 4203 Smith Lane, and they're identified in red on the plan. The lands have a lot area of 1,883 square meters and lot frontage of 15.9 meters on Smith Lane. The property does contain the corner of a cottage that straddles the lot line between the subject lands and 4201 Smith Lane. There is also a second wood-sided cottage that slightly straddles the lot line, as well as a dock and boathouse, which are all in disrepair and are proposed to be removed. The benefiting lands are described as 4201 Smith Lane and are identified in green on the aerial. And this parcel has a lot area of 2,388 square meters and a frontage of 16.6 on Smith Lane. Next slide. So both of the subject lands as well as the benefiting lands are designated shoreline residential within the township's official plan, and they are both zoned shoreline residential SR3 within the Township of Severn zoning bylaw. Next slide. So just as a summary, the application proposes to sever approximately 40.2 square meter parcel from the subject lands, and these lands are to be conveyed to 4201 Smith Lane. And this will leave a retained parcel of 1,843 square meters and a frontage of 15.9 meters. The amalgamated lands will contain both the severed parcel as well as the benefiting lands at 4201 Smith Lane, resulting in a combined lot area of 2,428 square meters and a frontage of 16.6 meters onto Smith Lane. There is also an easement proposed, which will recognize the location of the existing laneway by providing an easement for access purposes over 4203 Smith Lane in favor of 4201 Smith Lane. And this parcel proposed for the easement is 93.8 square meters. And next slide. So we did have a survey or a draft reference plan prepared. So the requests are from the survey. So we actually know what the severed and retained parcel dimensions and lot areas are. So the severed lands, which is 4203 Smith Lane, and it's identified in red, are to be merged with the benefiting lands at 4201 Smith Lane, identified in green. And the easement is outlined in a light blue, which shall recognize the existing laneway for access purposes. The retained lands are outlined in the dark blue color, and there is a pending purchase and sale agreement with the owner of 4207 Smith Lane, which is identified in yellow. And they are purchasing the retained lands. And as such, we have discussed with staff that the retained lands will be merged with 4207 Smith Lane as a condition of consent. And lastly, you can see from the survey the location of the aluminum sided cottage, which is being retained by 4201 Smith Lane, as well as a wood sided cottage, a dock, and a boathouse, which are proposed to be removed. So we do agree with staff that the demolition of this second cottage, the dock, and the boathouse structures would be required as a condition of consent to be demolished. And I will just say that part of the reason for the amalgamation to be conditioned is that it also resolves any potential zoning compliance issues that we have, as once the mergers happen, the two lots will meet all of the zoning and there are no minor variances required. And the last slide. So we did provide a thorough planning report and went through all of the policies. It is my opinion that the consent application is consistent with provincial planning statement, conforms to the official plans, and is in compliance with the zoning bylaw. I would like to thank Brad for all his time on this file, because I've had several emails and phone calls with him. And just to note that we did review the building department comments, and I have had some follow-up discussions with Brad and sent additional photos. And so these comments do relate to 4207 Smith Lane, which is not subject of the application before committee tonight. And that the owner of 4207, Mr. Walcroft, who is here with me tonight, will follow up with the building department. But we do not actually believe that a permit is required. So we will follow up with the building department following this. And those are my comments, and I'm happy to answer any questions.
Great, thank you. Do township staff have anything further to add to the materials and information presented by the applicant's agent?
Thank you, Chair. I will be pretty brief in my comments here, as Ms. Loft has covered the purpose and effect of the application in detail. I will just skip down here just to remind the committee that the entirety of the retained lands here in blue, as Ms. Loft pointed out, would be merged with the lands to the north. These lands, the retained lands, would become further deficient in lot area as a result of this consent application, which would deem them to be non-compliant with the zoning bylaw. However, the proposal to consolidate those lands with the property immediately to the north addresses that and ensures compliance with the bylaw, as Ms. Loft had noted. A condition has been recommended to ensure that amalgamation takes place following the application being heard. Just a couple site photos here for the committee's benefit. The image on the left here is the aluminum sided cottage, which was noted on the survey. This is the dwelling that is to be retained, which a portion of the land here to the right side of the cottage would be severed from the subject lands here, added to the benefiting lands, correcting the encroachment of this dwelling. The image on the right is the existing wood-sided dwelling, which the applicant intends to demolish as a part of this application, and a condition has been recommended by staff to ensure that that demolition and removal of the structure takes place. As detailed within staff report D25009, township staff have no objections to the planning opinion as presented by Ms. Loft in her planning justification letter, and therefore are recommending provisional approval of the application, subject to the recommended conditions as outlined in the staff report. The conditions are pretty standard for this type of application, including that a reference plan be prepared to legally describe the proposed severed lands as well as the easement, a copy of the electronic registration in preparation draft deed be provided for review by township staff, that the severed lands shall merge with and not be separately conveyable from the adjoining lands for both the severed and the retained lands to ensure that both of those transfers occur accordingly. Requiring an undertaking to ensure that both the severed and the retained lands are not separately conveyable from the intended adjoining lands that they are proposed to be merged with. Ensuring that the owners obtain and close demolition permits for the removal of the existing wood-sided cottage, dock, and boathouse on the subject lands. Ensuring that taxes are paid in full up to the date of request for issuance of the consent certificate, as well as ensuring that the applicant agree all fees and disbursements are their responsibility and shall be paid for, as well as that the conditions be completed within 2 years of the committee's decision. Staff do have a recommended motion for the committee, should you wish to see that. Thank you.
Are there any persons who have signed up virtually to attend this? Nope. So seeing no virtual ones, we'll move to, are there any persons in attendance who have either questions or wish to speak in favor or in opposition to this application? Seeing that there's none, I declare the public portion of the meeting closed. Do any members of the committee require further clarification or wish to provide comments on this application? Member Hawkins.
Through the chair to the applicant, what is the on-site sewage system for the existing cottage?
It actually is, through the chair, it is on 4203, but as part of the purchase and sale agreement, it is to be relocated on 4201.
So a part of that application would be for a new on-site sewage permit. Would it be part of planning or one of your notes?
If I can, through the chair, we actually would request that it not be a condition as part of the purchase and sale agreement, allow some time for the owner of 4201 to actually complete the real estate deal and then place the new septic system on 4201. So we specifically have not required an easement because it is to be moved, and there is an agreement between the two parties allowing the owner of 4201 some time to do that.
I guess how, from a township standpoint, though, like I get the agreements between two property owners, but that doesn't. How do we ensure that that's done? Because I just want to make sure that we're crossing our I's, dotting our I's, crossing our T's. There we go. To make sure that's completed. So how do I guess to follow up on Member Hawkins' question, how do we ensure that takes place?
Thank you, Chair. I would recommend that the committee consider a condition to ensure compliance with the Ontario Building Code through the proposed severances considered by this application. That would provide flexibility for township staff to work with the applicant to ensure that through this application, there is compliance with the Ontario Building Code to satisfy those requirements. And through that, it also ensures compliance with zoning bylaw with respect to the front yard setback for septic systems, because that's built into our zoning bylaw. So that would be my recommendation to the committee, would be an additional condition, being that the applicant demonstrate compliance with the Ontario Building Code to the satisfaction of the chief building official.
Does that satisfy Member Hawkins? I
Just
know I
through-
asked the question, but
through the chair. So that would mean, I guess you want to make sure the septic system's in place prior to the completion of the severance, so that it's a complete property and it's got its system.
Correct.
which differs from what the agent has recommended.
And-
Right? If it might, yes.
Thank you.
Yeah, go ahead.
Through the chair. Just taking into consideration the agreement that I know is between two parties, but would it be rather than the condition indicated by staff, could there be an additional section of the undertaking that that the solicitor could provide that would require that the septic system be moved on to 4201 within, well, it's a 5-year time frame is the agreement between the two parties to allow 4201 to finalize everything and to construct the septic system. So could it be dealt with through a condition via the solicitor's undertaking?
But then I guess my question to you would be, how do I confirm in 5 years that's done? So put yourself in my spot, put yourself, I'm, approving the application this evening. How do I ensure that's done? It's reliant on, in my mind, it's reliant on the two individuals that have the deal in place. What happens if property ownership changes during that time? How do I ensure I'm approving this application as it's seen this evening? How do I ensure that's completed if I leave it out of the conditions up there this evening? Go ahead.
Thank you. Through you. So we specifically did not ask for an easement because of the short time frame. And of course, an easement is 21 years less a day, which we don't require. It was only for a 5-year time period and hopefully shorter. So could perhaps through the chair to staff, but would there be the ability that an agreement be required as part of a condition of consent that would specify the time and require that the septic permit is obtained and closed within, well, a specific time period? I guess I would suggest 5 years because that's the agreement between the landowners. And that way the municipality does have the ability to ensure that the work is done.
And turn this over to township staff. I don't know how that goes in because I know your conditions are all there. But go ahead, let Brad speak to that.
Thank you, Chair. I believe that the 5-year timeline is too long for the township to consider this. The applicant would have a maximum of 2 years from today's date to satisfy the conditions that the committee may choose to impose in order to obtain a consent certificate to allow for the transfer of the lands. The individual property owners may have a varied timeline to allow for the registration of those consent certificates to allow the transfers of land to occur following those 2 years, which could get you closer to the 5-year time frame. However, the township would have 2 years to consider these conditions to be satisfied. If the applicant wishes to consider some type of agreement, the municipality may need some additional time to consider options with that. And I could suggest that the committee may consider a deferral of the application this evening to the next meeting in June to allow for some discussions with the applicant to look for alternative solutions, which we could explore at that time.
Yeah. Okay. So through you, I do know that the applicants wish to close the real estate deal as soon as possible. We've been working hard to get the submission in. And, everybody's spending money on this process. And so certainly closing the real estate transaction is critical. So we would be open to proceed with the condition.
Okay, I think that's appropriate to condition to put in. I also think from a liability standpoint, it might be better for the property owners to deal with this and get it dealt with, rather than have somebody's septic pump into some other property. I don't think some insurance company would like to hear that too much. So I think it's probably worthwhile to condition to be added in. So maybe township staff can just go over that condition again, what's being added in. And then in saying that, we'll probably have to update the motion to confirm the addition of the recommended condition, because it won't be in the staff report. Whatever the wording is. Brad's good at wording, I know that. So that's what Brad has typed up on the go. So the matter of consent application B-03-25, the application be provisionally approved subject to the recommended conditions included as attachment 5, which those are the current conditions, revised to include an additional condition to ensure compliance with the Ontario Building Code to the satisfaction of the chief building official. I'm good with that. I think that satisfies it. You're good with that?
Yes, thank you.
Okay. Is there any other further questions from the committee? No? So seeing none, I think we're good from a township staff perspective with that. So we've already got it. I just read it. It's motion COA 2025-20, moved by member Hiles, second by member Hopkins, that staff report D25-016 be received, and further that the matter of consent application B-03-25, the application be provisionally approved, subject to the recommended conditions included as attachment 5 to staff report D25-016, revised to include an additional condition to ensure compliance with the Ontario Building Code to the satisfaction of the chief building official. I am going to call for a vote. All those in favor? We are carried. The hearing for that application is now closed. You're free to stay for the remainder of the meeting or leave as you wish. We're going to move on to the next application. Would township staff introduce the application and report on any written response to the notice circulated for E3, which is an application for minor variance identified as A-07-25.
Thank you, Chair. As indicated, the next application on the agenda this evening is application for minor variance affecting the lands recognized as 1525 Port Stanton Parkway. The committee may recognize these lands alternatively as the Bayview Wildwood Resort. The subject property is currently zoned tourist resort commercial and form part of the overall Bayview Wildwood Resort property. These specific subject lands that form part of the overall resort contain the main lodge building and restaurant, as well as various seasonal accommodation units and other sort of tourist activity space. The variance is requested to facilitate the construction of a second-story deck, which would be attached to the front of the main lodge building. The applicants are seeking a reduced setback to Sparrow Lake of 4.6 meters where 20 meters is required. In support of their application, an environmental impact study prepared by Story Environmental has been submitted by the applicants. With respect to additional correspondence received on the application, comments from the building department state no objections to the proposed minor variance. Complete plans from an architect or engineer would be required at the building permit stage, as well as comments from the MECP with respect to the on-site sewage system and the additional seating being proposed through the addition of the deck. No additional comments or objections were received from Public Works, nor Fire and Emergency Services or the clerk's office. Mr. Pock from Morgan Planning and Development is in attendance this evening, and I do believe he wishes to address the committee.
Mr. Pock, come on up. You can present your presentation if you so wish, or add any additional information you would like.
Good evening, committee. My name is Jonathan Pock. I'm a senior planner at Morgan Planning and Development here on behalf of our client, Sunray Group of Hotels, who owns the Bayview Wildwood Resort, but is operated by Bayview Wildwood Resort staff. Next slide, please. The subject property is located on the south shores of Sparrow Lake. Just would like to draw your attention to the existing shoreline development along the shores of Sparrow Lake, as well as on the right-hand side, you'll see the mouth of the Trent Severn Waterway traversing into Sparrow Lake. Actually, can we go back one slide? Just want to maybe stand up here. Just to give you a little bit of context as well. So the subject property before you this evening is shown in red, but the Bayview Wildwood Resort also owns properties on the south side of Torpit Road, as well as another parcel that's located just to the south of the lands identified in red. They also own, not part of the resort, it's the cottages of Port Stanton, but it's further to the west up in this area here. Next slide, please. So as mentioned, the subject property is developed with the Bayview Wildwood Resort, contains various administrative offices, the various cottages that are used for tourist accommodations. They provide a number of recreational facilities on site and has been in operation for over 125 years. Does have a total of 0.975 hectares on, or of 0.97597 hectares, as well as about 287 meters of frontage onto Sparrow Lake. There are a number of private on-site services. I believe there's 5 to 7 septic systems that are on site. They're scattered throughout those properties that I mentioned before, as well as a large lagoon on the parcel that's on the south side of Torpit Road. Next slide, please. So this is an aerial image. I just would like to draw your attention again, that parcel on the south side of Torpit Road, just shown to the south. There's the CP rail line. Ironically, there's a train in the picture. That's pretty cool. This is kind of the accommodations in this area. There's the parking lot area. There's the kind of the play area. The cottages of Port Stanton are just to the west, and various cottages scattered throughout. The building that's subject to the minor variance application this evening is with the red dot on it. That's their main lodge building. It's currently undergoing internal and external renovations. The proposal this evening is to construct an attached deck onto this building on the water side, an existing patio area, and that is in conjunction with the ongoing renovations that are being undertaken on the building. Various shoreline structures as well as the beach area. It's okay, you can stay. That's okay. So again, this is the building. It's a photo from the lakeside. Again, there's the accommodation uses that are surrounding this area. So this building hosts a variety of events. There's the dining hall as well as other facilities underneath. Again, so the proposal this evening is for an attached deck. I have some images in my presentation, but it would be located under the second row of windows, kind of between the first and second story. Next slide, please. This is an image of the main lodge building, just showing that existing patio that is on the front side of the building. There's the well that's not proposed to be impacted. And again, the proposed deck is to be located over top of that portion of that existing patio. Next slide, please. Again, this is an image from the other side of the building. Would just like to draw your attention that there is sporadic shoreline vegetation here as part of the proposed attached deck to be constructed on the water side of the dwelling. This large tree is kind of the closest point to any vegetation that's existing on site, and it's proposed to be retained. It is quite close, but the footings have been positioned to ensure that remains. Next slide, please. As staff mentioned, this subject property is zoned C8, so it's tourist resort commercial use, and the existing Bayview Wildwood resort use is a permitted use. It is designated greenlands in the township's official plan. Next slide, please. So as mentioned, the application before committee this evening is a minor variance application to facilitate the construction of a new deck on the water side of the existing main lodge building. Is to be located and accessed via the second story of the existing building. There's no stairs or ramp from the ground to the exterior of the deck to be accessed by. The requirement is for a minor variance, as mentioned, is for a front yard setback and setback from the shoreline. And as mentioned, there's those ongoing renovations, and the construction of this deck would coincide with those renovations. They've strategically placed with hopes of gaining approval, but access doors to facilitate accessing the deck. Next slide, please. So this is an excerpt of the proposed site plan. Would just like to draw your attention to firstly the existing patio setback, which is shown in green. It's about 11.6 meters from the shoreline. In the blue bubble is shown to the existing setback to the existing building, which is about 8.7 meters. And then again, the proposed deck located on the water side of the dwelling shown in red, which is about 4.6 meters to the shoreline at the closest point. Next slide, please. This is a conceptual rendering of the ongoing external renovations. As you'll note, there is another story proposed. But again, this would be the proposed deck with the clear glass railing. These stairs are proposed, but they're not connecting to the deck. Next slide, please. So these are images that I showed before. I just wanted to highlight kind of in circle for you where that deck would be located above the existing walkway as well as the existing patio. Again, the vegetation is proposed to be retained. Next slide, please. In support of the application, we did have the technical documents such as the site plan, the elevation drawings, which I've shown, and an environmental impact study. I do have a short slide just summarizing the findings of that for you, as well as our planning justification report. Next slide, please. So as included in our application was an environmental impact study. The trigger of this application is due to the proximity of the shoreline of Sparrow Lake. It is identified as a provincially significant wetland. The findings of that study were that it can occur without direct impacts to the adjacent provincially significant wetlands, subject to the implementation of mitigation measures. Those include construction activities being set back from the shoreline, the installation of sediment fencing, and the restoration plan, which would occur in the area identified in green. So that area is proposed to be planted with native plantings to ensure the preservation of the area in blue was identified as an area that had dense vegetation within the water. So the study recommended that it was further buffered and enhanced in the green area. Next slide, please. Included in the application was a planning justification report. We have reviewed the 4 tests of a variance and concluded that it meets all 4 tests. Next slide, please. Again, just in summary, the application before you this evening is for a minor variance application to permit a reduced front yard setback. The Our application included the site plan and elevation drawings, as well as the environmental impact study, which concluded that development can occur. And the application would help facilitate, the current enjoyment, continued enjoyment of the property from both staff and guests that have been coming here for a number of years, and would also, again, coincide with those internal and external renovations that are ongoing. That concludes my presentation. If there's any questions, do my best to answer them. Thank you.
Perfect. Thank you. Do township staff have anything further to add to the materials and information presented by the applicant's agent this evening? And are you able to go through any recommended conditions?
Thank you, Chair, and thank you, Mr. Flock, for the detailed presentation. Just to expand on the comments provided by Mr. Flock, as outlined, the subject property is one parcel of land that, with other parcels of separate land, form the Bayview Wildwood Resort. This application is only to contemplate development on the identified parcel in red and wouldn't consider development on other parcels occurring. As shown, this is the location of that specific parcel that is subject to the application, which contains the main lodge building as well as the other various tourist accommodation units. As shown on screen is, again, the site plan that Mr. Pock had shared previously. Shown on, so the sort of north right side of the screen is the location of the proposed deck intended to cover the existing patio and walkway entertainment space that is already existing in what would possibly be on the future underneath that deck area. This is the elevation drawing. Again, as described by Mr. Pock, the deck as shown on the front is what is subject to the application, not the other proposed development that's ongoing on site. Similar to Mr. Pock's photos, staff have attended the site and captured the above site inspection photos. To the left of the screen is facing the front of the building where construction is ongoing, but where the proposed deck would be located. Similarly, a closer photo is shown on the right of the screen. This is a clear view of the front of the main lodge building, which the proposed deck is proposed to stretch across the entirety of the front wall. As shown on the right of the screen is also a further depiction of the lands from the other side of the building as compared to the previous slide, just to show that the deck would cover sort of an existing developed area. As indicated by Mr. Pock, these trees as shown here are intended to be retained to the maximum extent possible. As outlined in the staff report, Morgan Planning has provided a planning justification report that discusses the consistency with the PPS as well as the 4 tests for a minor variance. Included with their application was an environmental impact study. To expand on Mr. Pock's comments, the results of the study did conclude that there is a mapping error with the provincially significant wetland. It's not actually present along where the deck would be. Subject to the mitigative measures that were included in the EIS, therefore development would be safe to occur in the location that's proposed. Planning staff recommend the requirement for a development agreement to ensure that those mitigative measures are implemented on site, as well as that shoreline restoration plan that staff would work with the applicants to ensure that it upholds the intention of the EIS and the mitigative measures that are recommended. Therefore, planning and development staff have no objections to the provisional approval of the application subject to the recommended conditions. These are very small. The municipal taxes be paid today, that the construction's in substantial compliance with the plan submitted with the application, the establishment of that vegetation protection zone to protect the existing vegetation on the property as well as restore the shoreline area to the maximum extent possible, that the applicants provide those additional plantings as part of their shoreline restoration plan, the collection of securities for the implementation of the vegetation protection zone be provided and be held for 24 months, provided that they are grown to a healthy and safe condition. Provide for the fencing and the other construction mitigated measures as recommended by the EIS to protect that immediate shoreline area during construction, and that the applicants acknowledge that all costs associated with this agreement would be their responsibility. Planning staff do have a recommended motion for committee's consideration, should they wish to see it.
I commend you for reading that off the screen. That is talent. Are there any persons participating via Zoom this evening for this application? No? Or the next application?
maybe.
None at the moment. Okay. Are there any persons in attendance who have either questions or wish to speak in favor or in opposition to the application? Seeing as there are none, I declare the public portion of the meeting closed. Do any members of the committee require further clarification or wish to provide comments on this application? Member Kish?
So I guess just a question, with us working in close proximity to the fairly mature trees, what kind of protections are in place for those? Obviously, if they root systems are damaged, they'll die 3 or 4 years from now, and that's kind of outside of this. So how do we go about that and putting proper protections in place so that long term they still exist?
Through to the applicant? Agent? Oh, yeah.
I can take it if.
Or planning staff?
Thank you. Through the chair to member Kish. That would be the purpose of the development agreement and including those mitigative measures as required by the EIS. As part of that, the township would collect monetary securities for the protection of that shoreline area as well as the health of the plantings within the vegetative protection zone. So we would hold the securities for 24 months. Following the completion of those 24 months and a site inspection completed by staff to confirm that those plantings are still in a healthy and safe condition, then those monies would then be returned to the applicant. If it's determined that they're not, either the township would utilize those securities to restore the shoreline area, or the applicant would be required to undertake those works prior to the release of those securities back to them.
Seeing there's no further questions, I think we can move on to the recommended motion.
I have one thing.
Yeah, go ahead, Mr. Pop.
I just didn't want to, through the chair, I just didn't want to lose sight of one comment from the building department. I just would like committee to understand that there is a very detailed ongoing review of the septic systems right now, including the lagoon. We have been engaging with MECP and the representatives, and they are coming to the site. So I just wanted to make you aware of that.
So no reason to defer the application then.
Correct.
All right, good. I got a motion before me, identified as COA 2025-021, moved by member Bossy, second by member Kish, that staff report D25-014 be received, and further that minor variance application A-07-25 be granted provisional approval, subject to the conditions included as attachment 6 to staff report D25-014. And a call for a vote. All those in favor? We are carried. The hearing for that application is now closed. You're free to stay or go, unless you're representing the next application. No, just one this evening. No, we got one more application. So would township staff briefly introduce, I thought Mr. Pock was going to stay, but would township staff briefly introduce the application, report on any written response to the notice circulated for application for minor variance identified as A-09-25.
Thank you, Chair. Our final application for this evening, minor variance A0925 at the lands known municipally as 4276 Riverview Drive. This minor variance application requests minor variances to permit an increased height of a dwelling and an attached garage with a basement. This development is proposed to be set back 30 meters from the shoreline of the Severn River. The two minor variances that are requested are in the increased accessory building height for that garage with a basement of 7.6 meters, whereas the zoning bylaw normally permits a maximum height of 5 meters. The second requested minor variance is an increased principal building height of 9.7 meters, whereas the zoning bylaw normally would permit a height of 9 meters. In terms of correspondence received on this application, the building department has advised that there's no objection to the requested minor variances, but does advise that the comments relate only to the minor variance application and that building and septic plans have not been reviewed for compliance with the Ontario Building Code 2024. I would just add to that comment for the committee's benefit is that the applicants prepared a concept plan which identified a septic envelope at least 30 meters back from the shoreline. This property is quite large, and therefore the comments from the building department relate more to the fact that there is a large property here that a septic could be accommodated on. The Trans-Severn Waterway did advise the applicant in an attempt to remind them just that all in water and shoreline works would require a permit from the Trans-Severn Waterway, and that there were no comments or objections received from the clerk's office, Public Works, or the Fire and Emergency Services Department. The applicant's agents from Morgan Planning and Development are in attendance virtually this evening and do have a presentation which they wish to make to the committee. Thank you.
So I now call on the applicant's agent to please present your application with any relevant information. You're free to unmute yourself and turn on your camera and present as you wish.
There we go. Can everyone see my screen okay?
You see your screen? Yep.
Perfect. Good evening, Chair and Committee. My name is David Scarcelloni, Junior Planner with Morgan Planning and Development. And I'm the agent on behalf of the applicant, Mr. Wilmot, as it relates to application number A-09-25, pertaining to 4276 Riverview Drive and a minor variance application in the Township of Severn. So just moving into the location of the subject lands, the property is located on the south shore of the Severn River, nearest to the northern mouth of Sparrow Lake. The subject property has approximately 250 meters of frontage on the Severn River and a lot area of approximately 3.37 hectares or 8.3 acres. The subject property is currently vacant with no development on it. Vehicular access as well as shoreline access are available to the subject property. Vehicular access being via the private right-of-way, Riverview Drive, and obviously shoreline access through the Severn River are available. There is a hydro corridor running east to west across the rear of the subject property, so closer to Riverview Drive. And the surrounding uses are very similar. They're all kind of shoreline residential and recreational dwellings along the Severn River and along the north side in Gravenhurst, Bracebridge. Not entirely sure. The vegetation on site is typified as mature coniferous and deciduous trees, and along the shoreline, there's lush and mature vegetation spanning across the entirety of the Severn River. So moving forward, this was previously discussed on the last slide. Move forward again. Just moving in scope, this is an aerial imagery of the subject land, and as you can see in the top left corner of the screen, included a imagery of a summer season when all the trees are fully grown in. So the whole point of this is you can essentially see easier where the hydro line is, and the fact that the subject site is thoroughly covered by mature vegetation, which will mask the proposed cottage. So just moving into an overview of the minor variance application. It's proposing to construct a 2-story recreational dwelling with a 9.7 meter peak of the single pitched roof, together with a 7.6 meter high attached garage, which is considered an accessory building by the Township of Severn. The attached garage is of a gable roof, so that 7.6 meters was going to be between the peak and the trough based on the definition of height. And there's going to be an attached deck towards the front yard or towards the front of the proposed dwelling. The application seeks relief for the deficiencies in height caused by the single pitched roof and the attached garage gable roof. And the building and site plan designs comply with all other provisions of the zoning bylaw. Specifically to the variances requested are as follows. So to table 6.2 of the zoning bylaw, a maximum building height of 9.7 meters was requested, whereas 9.0 meters is permitted. In section 3.2.6 of the bylaw, we're requesting a maximum accessory structure height, which is going to be the attached garage of 7.6 meters, whereas 5.0 meters is permitted. It's also worth mentioning that the dwelling is going to be serviced by a private well and private septic system. Moving forward, here is a zoomed out kind of full site scale site plan. So as you can see, you can't really tell there, but on the next slide, I'll provide a zoomed in kind of inset map, which you can kind of tell in the bottom left corner there. But the septic envelope, the potential septic bed, and the dwelling are both set back 30 meters from the shoreline in accordance with the official plan. And that is the proposed approximate location of the dwelling. township staff mentioned, it is a very large site, so it can be moved back and kind of resituated based on the contour lines. But yep, moving in scope here is, as I previously mentioned, you can see 30 meters setback from the waterway, and that's to the deck, not even the proposed dwelling. And yeah, there's quite a steep slope to the south of the house, so it can be moved around, but in that approximate location is where we're looking to situate the dwelling. Moving forward, just for context, there's a site survey of 4276 Riverview Drive. Moving on, there's some building drawings with elevations. So it's kind of hard to see from here, but the top of the roof, the single pitch roof, is going to be 9.7 meters in height from grade, and the middle of the peak and the trough of the attached garage, which is on the right there of the top drawing, is 7.558 meters, which is why we're requesting 7.6. Moving on to the rear and right elevations, same thing, just different views of the proposed dwelling. Moving forward into a zoning compliance matrix of the proposed development, as you can see, the deficiencies are highlighted in yellow. We're compliant with all other provisions of the SR3 zone and the zoning bylaw. We're just requesting that 70 centimeter variance in height and 2.6 meter variance in accessory building height. Moving forward into the zoning and designation, the subject property is entirely zoned shoreline residential restricted access SR3 by the Township of Severn zoning bylaw and designated shoreline residential by the Township of Severn zoning bylaw, or official plan, my apologies. Furthermore, the property is designated rural by the County of Simcoe official plan. A planning justification report was submitted supplementary to this application, and it addressed the Planning Act, the Provincial Planning Statement, the County of Simcoe official plan, the Township of Severn official plan, as well as the Township of Severn zoning bylaw. Moving forward into a Planning Act and Provincial Planning Statements slide, the minor variance application was submitted with the provincial interest outlined in Section 2 of the Planning Act in mind. The application is consistent with the direction provided in the PPS, which was, in that opinion, was reached for the following reasons. It's consistent with the policies of the rural lands designation, and the development of one recreational dwelling on the property is not anticipated to negatively affect the Severn River shoreline based on the setbacks and appropriate development policies. Moving into the County of Simcoe official plan, the subject property is, as I previously mentioned, located within the rural designation. The proposed use on the dwelling is permitted, so the resource-based recreational dwelling or cottage. The proposal was made in accordance with the two main objectives of the rural designation, that being that the rural character of the shoreline area will be preserved, and the proposed dwelling will maintain adequate setbacks to the Severn River shoreline as previously seen in the site plan. Moving forward into the four tests of the minor variance analysis that we also provided in our planning justification report. The increases in requested building height and accessory building height are minor in nature due to heavy vegetation cover, as well as significant setbacks from the shoreline and adjacent properties. As previously mentioned, we're 30 plus meters back from the shoreline in compliance with the official plan. The proposed dwelling is going to be similar in scale and form to the surrounding dwellings. The garage will function visually and functionally as accessory or ancillary to the principal dwelling. Although the height is deficient and requesting a variance, it's going to be attached to the main dwelling, significantly less in height, and it'll function as secondary to the principal dwelling. The septic system is proposed to be adequately set back as well, as previously mentioned, 30 meters from the shoreline. The proposed use is permitted in the SR3 zone, as previously mentioned, and all other provisions of the zoning bylaw are met. And the proposed development also conforms to the objectives of the shoreline residential designation. So in conclusion, the application is appropriate, desirable, and represents good land use planning. The application is consistent with the Planning Act and the Provincial Planning Statement, conforms to the Simcoe County official plan and the Township of Severn official plan, and complies with the Township of Severn zoning bylaw. Minor variance application, as I mentioned before, seeks to permit an increased maximum building height from 9 to 9.7 meters, as well as the attached garage being 7.6 meters from the required 5 meters on 4276 Riverview Drive. The increased building height and accessory building height will facilitate, as I mentioned, one new resource-based recreational dwelling, which is consistent with the surrounding area, as well as the attached garage accessory structure. And as stated on the last slide, the minor variances meet the four tests of a minor variance. And I also want to mention that we reviewed the staff report, have no comments or concerns with the recommendations or conditions provided. And upon approval of this application, we will also be prepared to submit a vegetation protection map to township staff for them to prepare the development agreement mentioned within the conditions. So that concludes my presentation. And at this point, I'd like to invite any comments or questions from members of the public, either on Zoom or in person, or members of the committee. Thank you.
We will get there in due time. Do township staff have anything further to add to the materials and information presented by the applicant's agent this evening? And are you able to go through any recommended conditions?
Thank you, Chair. For the committees and members of the public's benefit, I did just want to clarify, you may have seen in some of these slides that there were 2 parcels outlined on there. This property historically has had 2 assessments from MPAC, which is the Municipal Property Assessment Corporation. Those 2 assessments, although assessed separately, are one legally conveyable property. Since the application has been submitted, township staff have corresponded with MPAC and provided the legal opinion by the property owner's lawyer, confirming that the 2 parcels are not separately conveyable and therefore form one piece of property. And MPAC is in the process of updating their mapping to reflect that. They did agree and are proceeding with a consolidation. It just takes time for the mapping to be updated, but I just wanted to bring that to the committee's attention as well as the public's, just for clarity. Moving forward, these lands will be only known as 4276 Riverview Drive. As Mr. Scarcelloni pointed out in his presentation, the applicants have provided for a 30-meter septic and building envelope setback from the Severn River. That is a requirement of the township's new official plan, which imposes a larger front yard setback from shorelines where feasible. As also mentioned in the township staff report, Section 12.4 of the township's official plan establishes policies that guide and direct shoreline development to ensure that the natural function and features of the shoreline area are preserved and enhanced moving forward through development applications. Township staff have recommended a condition of a development agreement to ensure that that shoreline remains in a natural and relatively undisturbed state, still accounting for the usability of the shoreline area to allow for a limited shoreline access pathway down shoreline structure envelopes and normal use of that as contemplated and permitted by the zoning bylaw, while also ensuring that the natural state of that shoreline area is retained. So with that, the recommended conditions are just a couple slides ahead here, but before we get there, I will just cover a couple of site photos here. This is the property as you're approaching Riverview Drive. It is a little bit difficult to see on the screen. However, right in this area of the photo is the hydro easement. So this is about 2/3 of the way back on the property. The only site alteration that has occurred has been the installation of a private driveway from Riverview Drive into the property. This is a picture of the shoreline area. You can see the Severn River through the trees out here and the relatively undisturbed state of that immediate shoreline area, which that development agreement would protect and preserve. The applicant covered this, but just as a reminder, they are demonstrating a minimum 30-meter setback here for both the septic envelope outlined in green, as well as the building location together with the deck, again at 30 meters. So as discussed within the staff report D25-015, the PPS county and township official plans, as well as the 4 tests, township staff have no objection to the professional planning opinion as expressed by the applicant in their PJR. And for those reasons, township staff have no objections to the provisional approval of the application subject to the recommended conditions. Those being that municipal taxes are paid to date, The construction shall be in substantial compliance with the plans submitted with the application, as well as that the property owners enter into a development agreement with the municipality pursuant to section 49 of the Planning Act in order to establish a vegetation protection zone at a minimum width of 30 meters, protecting the as existing vegetation on the property as of May 8th, the date of staff site inspection, and restore the shoreline area to the maximum extent possible should vegetation be removed within that 30 meters during construction, as well as providing 4 additional plantings if required to achieve that first condition being the protection of the existing vegetation. The collection of securities for the implementation of a VPZ and its retention for at least 24 months if additional plantings are required. Ensuring that silt fencing and construction related measures are implemented during construction to protect the shoreline area, requiring a lot grading plan prepared by a professional engineer with confirmation of setbacks provided by an Ontario land surveyor to ensure compliance with the committee's decision, and noting that all costs associated with that agreement and the registration on title would be the responsibility of the property owner. That concludes my presentation. If there's any questions of the committee, I am more than happy to answer. Thank you.
So there's nobody joining us virtually. So are there any persons in attendance who wish to speak or provide questions to the application? So if there's no further questions or comments, I declare the public portion of the application closed. Do any members of the committee require further clarification or wish to provide comments on this application? Seeing as there's none, I call for a motion. The motion before us identified as COA 2025-022, moved by member Kish, second by member Hawkins, that staff report D25-015 be received, and further that minor variance application A-09-25 be provisionally approved, subject to the conditions included as attachment 6 to staff report D25-015. I'm going to call for a vote. All those in favor? We are carried. The hearing for that application is now closed. There is no reports. There's no correspondence. I'm going to call for a meeting for a motion for adjournment. Motion COA 2025-23, moved by member Hawkins, second by member Bossy, that the Committee of Adjustment be adjourned at 9 p.m. on Tuesday, May 20th, 2025. They better be green. I'm going to call for a vote. All those in favor? We are carried. Good night.
Better be